Hello, I'm Roman Kubiak. I'm head of the Private Wealth Disputes team here at Hugh James, and I'm joined by Ryan Taylor, my senior colleague in our Private Wealth Disputes London team. And today we're going to be talking about the Inheritance Provision for Family and Dependents Act 1975. We'll keep it short and call it the Inheritance Act from here on in. So, Ryan, how are you, sir?
Good, thank you, Roman. How are you?
Yeah, very well, thanks, very well. So today we're looking at a claim that we deal with a lot in our practice, which is the Inheritance Act.
Yep.
So, I guess the first thing people might want to know is who can bring a claim and what is the Inheritance Act? So, do you want to tell me what the Inheritance Act is and what its purpose is?
So I think it's important to distinguish the Inheritance Act from a general will claim because we're not looking at disputing the validity of a will or what the testator chose to do with their distribution or inheritance choices. It's looking more at saying, despite the will or the intestacy rules that apply to the estate, whether reasonable provision was made for me as the claimant or any other party who's bringing the claim if we're defending the claim. There's a broad category of people who can bring these types of claims. They could include the spouse, so a widow or widower who's been left behind and perhaps hasn't received what they expected under the will. It could include children of the deceased, so someone who's been cut out for whatever reason, or again, receiving a disproportionate share to other people.
And spouse, within that category, you've got civil partners as well, don't you? So
We do, so anyone who's classified as legally married in England and Wales doesn't include cohabiting partners within that definition, but they are another category who can bring a claim, but there will be a different provision claim that they can make because of the limits to what's maintenance or what's not.
And because there's no such thing in the law of England and Wales as a common law spouse. It's a bit of a misnomer, isn't it? So
it is. There is no such thing. So there's an additional hurdle that they'll have to overcome to prove the nature of their relationship, whether they're living in the same household, the extent or length of the relationship. Very different when you don't have the paperwork to prove the relationship.
Yeah.
The categories of people who could claim would be people who are treated as a child, so may not be a legal child either by birth or adoption.
So like a stepchild, for instance, even a grandchild. Anyone who, I guess, was in that position where the deceased person was providing for them and assumed a parental responsibility.
Exactly, a pseudo foster child, something like that.
Yeah.
Someone who can bring that claim. And other types of dependents who may be able to show an ongoing interdependence financially or relationship-wise that may not strictly fit within the treated as a child category, but was someone who was receiving benefit from that person during their lifetime.
Someone essentially financially maintained by them for money or money's worth. So I guess an example could be if say the deceased had portfolio properties and was letting a friend live in a property rent-free for a number of years, they could perhaps qualify if that person died and didn't either leave them anything in their will or didn't leave a will at all, and their friend then finds themselves potentially homeless. They may have a claim.
Potentially there, yeah.
So those are the broad categories of claimants, and then I guess you've got the different standards which apply, so what the court can award or what settlement you can agree depending on who you are within that list of claimants. So I guess you've got the two standards. One is the maintenance standard, it's called, and then the other one is a higher standard. So if we look at spouses and civil partners, they can claim for, the wording within the Act is such financial provision as is reasonable, irrespective of whether or not it's necessary for their maintenance.
Yes. So, the word reasonable is thrown around a lot in this piece of legislation, which is obviously very helpful and not confusing in any way to clients or to us. No. But it's allowing the court the discretion to make decisions that they need to suit the unique specifics of the case.
It's a very case-by-case basis, isn't it?
Exactly right. They need to apply the facts to a range of criteria that we'll talk about, hopefully, in a moment.
Yeah.
The spouse generally has a slightly less limited ability to make a claim. It's not limited just to their maintenance, it could be additional capital. So it's slightly less restrictive, acknowledging the nature of the relationship and the supremacy of the spousal relationship perhaps to the claim by someone who's treated as a child.
That's right. So I guess what the court tends to, or one factor the court considers when it's looking at claims by spouses or civil partners, is what provision they would have received if the marriage had ended by divorce rather than by death. So usual starting point, I guess, is what they call it the divorce standard, and it's the yardstick of equality.
Exactly.
So you tend to start from the position of an equal division of the matrimonial part, which is taken from a family case called White and White.
Exactly.
And then the court can sort of deviate from that either upwards or downwards, can't it?
Yeah, so there's kind of the presumption, a really rough guide of a 50-50 split, let's say, where they're taking into account the matrimonial assets. So what is all of the combined pool of the couple? And then if we're dividing that 50-50 in a divorce situation, so if they divorced the day before one of them passed away, what would the outcome have been then? And let's compare it to what it might be under an Inheritance Act claim. And so we're trying to kind of balance the ledger in that.
I mean, the obvious point there, I guess, is that the other big factor the court will consider is that in a death situation, the court only needs to take into account one person's, at least within the couple scenario, one person's needs.
Exactly.
Everyone's passed away.
With the family law claim, then you're looking to balance the ongoing needs of both parties, whereas if one of them's passed away, their needs are limited or non-existent. So the court may take that into account, but again, it's not determinative. It's just a yardstick or a way to test what the provision they're thinking of giving or what's being claimed against what might the situation have been. Trying to make sure that no one's unfairly impacted by the fact that they suffered this bereavement rather than going through a divorce process.
And it's a two-stage process, isn't it? Because you have to show, first of all, that you're eligible, and secondly, that the will or failure to prepare a will means that adequate financial provision hasn't been made for you. So that's the spouse and civil partners, and the courts have both been generous in making awards for them, but at the same time, there have been cases where the courts haven't awarded anything to spouses or civil partners by reason of the fact that they consider that they've been adequately provided for. And then you've got the other eligible claimants, so your children, that could be adults, children or minors, you've got people treated as a child, cohabitees, and they're entitled to such financial provision as is reasonable for their maintenance. And again, maintenance is another word that features a lot in the Act and in the cases, and it's not a one-size-fits-all definition, is it? It's very much case-specific. So I guess what we're looking at when we're thinking about maintenance is exactly that. What's needed to maintain that individual, often taking into account the standard to which they become accustomed during their lifetime. Exactly. So it's not to fill their lives with splendour and magnificent wealth, but nor is it to leave them absolutely destitute.
Yeah, the court will look into what the current circumstance of that person is, what their expectations may have been to maintain their current living standards, and one of the factors that they can view is how that living standard was perhaps being met or contributed to by the deceased during their lifetime. Yeah. So that can vary greatly depending on the stage of life the claimant is in. Within the category of children, obviously you've got differences there between adult children and minor children. Minor child who may be one of, say, 4, for example. You've got 3 adult children who've all had all of their education, university expenses paid, but a child later in life that is still going through that needs provision to make sure that their costs all the way up to attaining majority are met, but then future education that the siblings may have received, a will that splits at 50-50 or the intestacy rule splitting equally between them is not going to balance that situation where you've got someone who's going to have higher level of needs.
Yeah, it's and again case by case, because it could be that you could argue that the younger child, the minor, has a greater earning capacity than, let's say, a much older sibling, if you had that. But as you say, I think those considerations about education costs, about the future, those are key considerations. And then it's probably useful to look at cohabitees, so people who live together. And the qualifying criteria there to bring a claim under that head is that a person had to be living with the deceased as their husband or wife, so not actually, but not not sort of de jure, but de facto husband and wife for the period of 2 years immediately prior to death, and living in the same household.
In the same household, which is, again, sounds relatively strict, but has been pushed by the case law in terms of what can fit within the same household, because a couple who may not always live in the same home can still be within the same household. So someone who works in a different city to their partner, but goes and spends every weekend with them, and then when that partner is in their city, stays with them, could potentially fit within that category.
And even someone, I guess, who goes into, if someone has to go into care, let's say in the run up to their death,
exactly,
that still constitutes. The courts have been generous, or not generous, but the courts have taken a very sort of fair approach in saying, look, that was forced upon them. They were still within the same house, or the same family unit, effectively.
The court will take into account the circumstances of their relationship to determine that. But the 2 year rule itself is relatively
It's a strict rule, yeah.
So the fact that somebody had been living in the same home as a couple for 18 months is going to be a problem for them.
Yeah.
They'll have to look at perhaps whether they can fit in with another category of eligible claimant.
And that's and the evidence, because I mean, we've dealt with lots of claims like this, and you look at things like utility bills, statements, letters, photos, evidence from people who knew the couple potentially, all that to build a picture to see if these people are eligible.
Yeah, I mean, that's worth hammering home, is the living as a couple has to be to the outside world.
Yeah.
It's a relationship under the dark of night isn't necessarily going to tick that criteria, because if the world doesn't view you as this couple, then you're not going to be within the category of a cohabiting claimant.
And evidentially it'll be very difficult to prove.
Exactly.
So, and then we won't labour too long on the claim. I think we've covered those quite well. But then looking at the factors the court considers, so you've I guess you've cleared the first hurdle, you're eligible, and then to look at whether the will makes reasonable or intestacy makes reasonable financial provision, you're looking at Section 3 of the Inheritance Act, which sets out the factors the court considers or can consider when it takes into account what provision, if any, to make. So what financial award to make, and there you've got factors such as the financial resources and needs of the person claiming, both now and in the foreseeable future.
Yep.
So a lot of that will depend on age and life expectancy. You've got the same thing that applies to any beneficiary of the estate already, so their financial needs now and in the foreseeable future. The court can look at the size and nature of the net estate. So does it comprise property? Does it comprise liquid assets? Are there various trusts? Are there assets abroad? Look at any disabilities, won't it? And then the conduct of the parties, any obligations and responsibilities owed by the deceased. So, for instance, a good example there is if they treated someone as their child. And then there's a catch-all, isn't there, which is any other matter which the court considers to be of relevance. So, again, it's sometimes it can take a bit of mental gymnastics but you can use these factors and apply these factors, and it's important that you do when if you're bringing a claim or if you're defending a claim. It's important to consider those factors as well, as they will allow you to help you towards realising what an award might look like.
I think the point on defending a claim is useful as well, because we don't just act for claimants, we act for defendants.
Exactly.
And the conduct of the parties is often a key point that people come to us with and say, well, yes, X was excluded from the will, but here's why.
Yeah.
And then gives us the full back history of why this person shouldn't have been in the will in the first place. And the court can take that into account. The other factor that you raised is the financial needs of the other beneficiaries. So in England and Wales, the court will try to uphold the freedom of the testator to make their own decisions on what happens with their inheritance as far as possible, and it's only in exceptional circumstances under this Act that they will vary those provisions or distributions.
That's because we've got a common law system here, which effectively means that we are free to dispose of our estate as we see fit. Exactly. So we've got what's called freedom of testamentary disposition. We don't have what's called forced heirship, as some civil law jurisdictions in Europe, for instance, have, and even partly in Scotland. But with that freedom then comes these checks and balances, which is what the Inheritance Act is there for, effectively.
So the default position currently would be what the will or the intestacy rules say, and so a person making a claim is looking to change that. The beneficiaries who may be defending the claim aren't necessarily forced to raise a positive case in their defence. They can rely on the court trying to always uphold the freedom of the testator and make the other side prove their claim. But some defendants are in circumstances that are similar or worse than the person bringing the claim, and so they're given the opportunity to raise those in consideration for the court, so they can throw in perhaps my circumstances are worse, I've come off work because of an injury or disability, and so I need this inheritance that I'm currently entitled to, and asking the court to limit any provision they may give, if any, to this claimant, because it's going to have a detrimental impact on them. So when we're defending claims, we're all taking exactly the same factors into account, just flipping them on their head.
Exactly. And we've spoken about, obviously, about England, Wales and it being common law jurisdiction. I think the point about it being England, Wales is important for domicile, because to be eligible, to bring a claim, the deceased must have died domiciled in England and Wales. And the key point with that is domicile you can get arguments about domicile.
You can.
And I think the big one is, the starting point is you look at the grant of probate, which will normally, it will always say whether the deceased died domiciled. That's the starting point. That's good evidence. It's not absolute. That can be challenged. But generally speaking, domicile, everyone's born with what's called a domicile of origin. So that's effectively, and rather archaically, it tends to be where your father was born. So you inherit it from your father, unless your parents weren't married, then it's from your mother. And provided you can establish that domicile, then a person can bring a claim. Now, that domicile can change. So if you move abroad with the intention of setting up a home abroad and, let's say spending or living out the rest of your days in another country, then you can acquire what's called a domicile of choice.
Yep.
But your domicile of origin is sticky, whereas your domicile of choice, if you then return back to England, Wales, you abandon that domicile.
Domicile of choice, the importance there is the intention for permanency. So it's not someone who goes and lives in Spain for 6 months of the year and then comes back, or somebody who's intending to live there for a short-term contract. The fact that they reside there during that period won't necessarily change their domicile of choice.
Yeah.
Their domicile of origin will still be in place.
And then we've got, obviously, the time limits under the Act. So this is something which can catch the unwary practitioner or claimant out, and then can be used when you're defending these challenges, because it's I say strict, but generally speaking, you have to bring a claim within 6 months from what's called the grant of representation. That can be the grant of probate, if there's a will, or grant of letters of administration, if there's no will or no appointed executors. So, and that 6 month time limit, while it's there and it's enshrined in the Act, the court does have discretion, doesn't it?
They do, yeah. So it's from the intended final grant of representation. So if you've got perhaps an interim grant to deal with certain assets or litigation, that won't count. Is when you get the final grant, whether that be in solemn or common form, depending on the circumstances of the case. But yes, 6 months, you need to have issued your claim. You don't necessarily need to have served it, but you need to have issued it within that time. And usually you'd have expected to have already engaged with the other party to put them on notice that you're intending to bring that claim. But the issuing is the point. The court has the discretion under application to extend that period where there's circumstances that make it worthwhile for the claimant. That could include things like perhaps a lack of knowledge, whether you didn't know that the person passed away, where you hadn't had the opportunity to receive specific advice on that point. In some cases, that's been allowed. So usually they would be quite limited. The court is always very lax at adjusting limitation periods because they've been prescribed by Parliament for a reason, and so they don't want to overrule those or undermine the existence of limitation.
That's right, there's a policy reasoning behind it, isn't it, which is that beneficiaries and executors and personal representatives need to have comfort that once an estate is administered, it's administered, so that's why these time limits are there. But there have been many cases debating the factors, looking at factors which the court will consider if it considers an application to bring a claim out of time, as you said. And I mean, there have been some cases where people have been allowed to bring claims 26 years after the grant of probate.
Those would be very much the exception.
Absolutely.
And I think the whole industry was kind of shocked when that one went through. But
there were
again,
good reasons, weren't there? Because
unique
there you had an asset which hadn't been administered, and so that was a good factor. It was a claim
by a spouse.
So, and that's the thing. I think the courts. What tends to, or what seems to have come out of these cases, is the two big factors seem to be, firstly, what are the merits of the claim? So, putting to one side the delay, how strong is the claim on its own merits, and then what are the reasons for the delay?
Yeah.
And I think that those tend, at the moment at least, those tend to be the big factors that will sway the court.
Exactly.
And I mean, there are various other provisions within the Act, so buried within there, which are actually, again, for the unwary person, they might not spot these, but which are very useful and which obviously we see a lot. And I mean, a good example of that is reading back provisions. And effectively what that means is that if you have an order, and it's important that there has to be an order under the Inheritance Act, then that applies retrospectively for tax purposes. So let's say someone leaves their entire estate to their friend instead of their spouse, and let's say that estate is subject to inheritance tax. If the spouse brings a claim, and then there's and there's an order under Section 2 of the Act, then for the purposes of inheritance tax and any other taxes, effectively that award will be read back as if it applied from the date of death, and therefore they'll receive it free of inheritance tax.
That can be a useful exercise in negotiation and settlement if we're looking at trying to determine this before we get all the way to trial, because there can be tax advantages to the estate in perhaps choosing which beneficiaries take what type of inheritance. So where we can employ that to the advantage of the estate and perhaps bring about a financially more palatable settlement, then we'll do that.
Absolutely, and I think that's where knowledge around tax is crucial, because that's something which people maybe not forget but overlook. There are things, using the residence no rate ban, for instance, using the various reliefs, spouse relief, charity exemptions. We act and advise a lot of charities about these types of claims. So using and being aware of those provisions is really important. And the Act also has various parts which allow you to bring in other assets, doesn't it? So let's say a person dies and their estate ostensibly is worth 500,000, but they own the joint property, and that property passed by what's called survivorship to someone else. The court has the ability to bring in the deceased share of that property back into the pot, even if it was a joint property or joint account, to bring that back into the pot to determine what award to make. And it can also deal with things like anti-avoidance, can't it?
Yeah, I think the ability to claw back in assets is a really important point, because we'll often find cases where a parent has brought someone else onto the property title to enable them to continue a mortgage. Perhaps that's through a breakdown of relationships where they needed to pay out a spouse, or perhaps they were looking at a right to buy scheme some time ago where they couldn't get the finance, but by bringing in a child, putting them on the title, they're able to get that now. Those assets may pass automatically by survivorship to whoever else is jointly on the title. The court can see through that and say, well, actually, no, that value should form part of the estate for the purpose of this claim. So that can't be used as a way to circumvent. As you say, also the anti-avoidance provisions are looking at where somebody may have perhaps taken some rather creative estate planning steps, whether under advice or not, to distribute their estate before they pass away. And sometimes that's with the intention of minimizing inheritance tax. Sometimes it's with the intention of screwing people over.
Precluding a claim under the Act.
Exactly. So if someone's looking at making sure that their favourite child receives all of the estate, they may look to transfer the property into their name sometime before they pass away, and the court has the ability again to see through that and perhaps say, if that took place within 6 years of the date of death and with the intention of defeating a claim, exactly, another limitation that you need to take account of. If it was with the intention of defeating a claim, then no, we're going to see through that.
And again, it's that intention, isn't it? That's key.
Exactly.
You have to have the intention of making that payment or that transfer specifically to exclude a claim.
And how you evidence that can be the tricky part as well, particularly if we're talking about a transaction that took place 5 years ago. But I mean, there's obviously land registry records available where you can look at a transfer for natural love and affection, where perhaps natural love and affection doesn't really explain what's going on, then we can start to build the case.
And there's conveyancing files, solicitors' files, things like that can be accessed. I mean, another really useful order that can be made, especially for those who are really impecunious or struggling financially, is an order under Section 5, which is effectively that while the case is going on, because what I will say is the vast majority of cases settle before trial. But if a case does go to trial, that can be a timely process. And the court has the ability to grant interim relief during that period. So you can make an application under Section 5 of the Act, say, for ongoing maintenance needs. So we had a case where we had our client was being provided with an annuity, weren't they? Regular monthly sum to tide them over, paying their rent and so on until the claim was finally settled. And these are really, really useful provisions. Now, we've obviously then, I mean, that's looking at during the death, but I guess if we take a step back, going back to the anti-avoidance, people also try to put in clauses in their wills, don't they? What are called, I guess, forfeiture clauses or no contest clauses, to say, if so-and-so brings a claim, so I leave a gift of, say, £10,000 to my child, but if they either challenge my will or bring a claim under the Inheritance Act, then they forego this gift of £10,000. And the important point to say is that you can't sort of overreach the court's jurisdiction. The court still has jurisdictions. The court can still look at whether a will is valid or whether there's a claim under the Inheritance Act. So these clauses, they won't absolutely stop a claim,
No.
but they can have persuasive effect, and ultimately if a person is unsuccessful in their claim, they do forego their
that gift may be defaulted on. So when we're looking at a case where that forfeiture clause may exist, we're trying to make sure that we have an early view of whether this claim is worthwhile pursuing and whether we're going to be in a position to hopefully achieve more than their entitlement under the will. So if they're receiving £50,000 and they're an adult child who's still working and may have no maintenance needs beyond that £50,000, but they're annoyed that they only got £50,000 when their siblings got more, we may need to advise the client on the economics of pursuing that claim when they're potentially putting more at risk. That's a pretty generous gift clause and doesn't come across our desk that often. Usually we're looking at the £1,000 to £10,000 in a forfeiture clause, and in a lot of circumstances the claim is worth pursuing and defaulting on that gift because they're more punitive than generous.
And it's important to have that frank conversation, to be honest about it, because you're not doing the clients any favours.
Exactly.
If you lead them down this, you're incurring unnecessary costs, and that's where I think having that ability to be frank and honest with the client about it, and to know about these claims and to understand actually where any prospective award lies. And then you've got the position of executors, administrators, personal representatives who are dealing with the administration of the estate. Again, I mean, we act for many of those, and their role is one of neutrality. And what that effectively means is that their duty is to administer the estate, to provide information to all parties that's reasonably required to allow them to pursue or defend the claim, but effectively is to adopt a non-partisan approach. But it doesn't mean that a person who's an executor, for instance, can't also either be a claimant or a defendant. You wear two hats, but you just make sure you separate those two roles, and provided you do that, as an executor or administrator, you're entitled to your costs from the estate, through what's called effectively an indemnity. And within the Act also there's built-in protections for personal representatives. So that 6-month time limit we spoke about at the start, if that 6-month time limit has passed and there's no notice of a claim, the personal representatives and executors can distribute the estate, and if any claim is brought, they're not personally liable.
No.
And if a claim is brought, then the person who's bringing the claim would then have recourse to claw and potentially any distributions from the beneficiaries.
So you need to add those beneficiaries back into the claim to make sure that we can recover any assets if a further award is made. Exactly.
And I think the key premise behind that is that, as you said at the start, is that it's because the reason personal representatives adopt a neutral role is because this isn't a challenge to the validity of the will. So it's not saying the will is invalid, it's just saying that it's more a challenge to how the estate's evolved.
Exactly.
So. Great, well I think that sums up our run through of the Inheritance Act. So thank you very much, Ryan, and thank you for watching.